regarding sufficiency of the evidence, I'd want to first focus on the co-defendant testimony, which I think should be equated to accomplice testimony. Now, I understand that this court is not able to look at credibility of the witnesses. However, I think that what Mr. Soto Morales said or did not say goes beyond the scope of credibility. He did not even admit to the charge that he had pled guilty to. Part of the agreement that came up in front of the court that the jury heard was that he would agree to testify truthfully. And so either he lied when he took his guilty plea or lied in front of the jury about his involvement. Further than just, and I believe it's distinguished from...
So was his plea before the trial or after the trial?
It was before.
Okay. And so was he cross-examined on the fact that he said one thing at his plea as opposed to what he was saying during the trial?
Yes.
Okay. So the jury heard that?
They did. And understanding that it's a very kind of limited scope, but I would say that further, he was not able to establish that he could have in any way been able to contribute to the conspiracy or the facilitation of the conspiracy regarding the aggravated robbery. Even the testimony that he does acknowledge might relate to this robbery that was discussed before the actual incident. They said, oh, well, they were talking about a robbery, or they said we're going to rob, okay? Well, they don't mention Mr. Patterson, my client. The other defendant involved in this three-person case was his biological brother. From the stand, Mr. Soto Morales testified that he would not be willing to testify against his brother, and as part of his guilty plea, did not have to do that. Only he had to testify against Mr. Patterson. I say that he was not able to offer any evidence to support the robbery because he is one saying that I was not involved in it, I wasn't a lookout, I didn't hear the plan, and then two says there was no plan. He mentions very vaguely and just, at an undisclosed time before they left that, oh, they said something about robbing. Okay. Well, they don't mention who, they don't establish a plan, they don't establish what any acts are going to be, who's going to do what. He then says that he's not able to see or hear anything except for the gunshots. And so the reliability of his evidence that, oh, he's telling the truth when he's not admitting to even the guilty plea that he took, I believe goes beyond the necessary scope for credibility and supports that without any corroborating evidence, that was the only evidence the jury had to pull on.
What did he plead guilty to?
He pled guilty to specifically conspiracy to commit aggravated robbery. And count 2 was facilitation of conspiracy to commit. And I think he got bumped down to avoid the required 85% sentencing, I think, to the C felony, and was given maybe an 8-year sentence under State v. Hicks so that he would be able to be time served and was close to finishing his suit by the time he testified. Finish his sentence by the time he testified. But he pled guilty to the actual robbery of which my client was a co-defendant. And then during trial said that he did not commit the robbery. He was not involved with it. And, I could understand that potentially maybe he's trying.
But I understand your point, but, an individual may plead guilty to something they think they didn't commit, but they recognize I'm going to get convicted of something higher if I challenge this. And so, then when he testifies at trial and says, I really wasn't part of the robbery, is he really lying, or is he now getting to express how he really feels about the case against him?
I think that because the requirement of the robbery is so crucial for the felony murder conviction that it must be given a bit more attention than just simply kind of obfuscating about culpability. Without the belief or the fact that a robbery had been planned, Mr. Patterson wouldn't have been found guilty of felony murder. And so the jury must have found that a plan to rob or that some other felony was being committed while Mr. Love, the decedent, had passed away in order for the conviction to stand. Without and I'm arguing that there was no other corroborating evidence of the intent to rob or of a robbery occurring other than Mr. Soto Morales saying that, yeah, I heard them talking about potentially doing a robbery.
I thought your client told the police that, I don't know how to pronounce the last name, M-E-J.
Right. Mahias, yes, sir.
Took marijuana from the victim?
I saw that, and he did say that, but I believe that,
So is that not theft?
yes, but it's not,
And if you're there as part of this group, could you not also be then charged as a co-defendant with the theft, be criminally responsible? And/or could you not then be, as a result, criminally responsible for the death?
I would distinguish if it was a theft, then that would be a misdemeanor theft under 1,000. And so I don't know if the felony murder statute would apply.
It just says theft.
Just says theft.
It doesn't say felony theft, it just says
Okay.
theft.
Then I would argue that him witnessing the theft is not proof that he was aware of his co-defendant's actions beforehand. And I believe in order for the felony murder conviction to attach, that the reason that that sentence is so powerful and that it comes with that automatic life sentence is because they're saying, well, look, it doesn't matter if you planned on someone dying, you planned on robbing someone, you planned on committing a violent felony, and once that violent felony occurred or the attempt of it, someone passed away. Well, I don't believe Mr. Patterson saying, I saw him take that, equates to, oh yeah, that's the plan for me to go and rob this person. You know, two people can go in and not have any intention on what's gonna happen, and just simply witnessing the acts of who's now considered the co-defendant, I don't believe establishes that this was our intent and our plan, and I believe that intention would be necessary, although the intent to kill is not, but I think the intent to rob must be satisfied, and so far, the only intent to rob we have is that because Mr. Soto Morales said, well, I heard them saying, oh, we might do a robbery or we're gonna rob them, with no specificity to who said what, how it was going to happen, and then obviously the denial in trial, for trial testimony that he wasn't even aware or was not there. Lastly, Judge, and this is my,
Can I ask you one other
of
question?
course,
And you're talking about the fact that your client said that he told the police that marijuana was taken from the victim.
Right.
He was present when that happened.
right.
And are you saying that there had been no discussion between your client and Mr. Soto Morales or the other gentleman before about taking stuff from the victim?
I'm saying that there was no evidence presented at trial for that, that the only evidence
And
that,
then- Okay.
Yeah.
And then, well, the second part is that after the marijuana was allegedly, was taken by the one gentleman, it was at that point in time that your client used his gun, and he stated that he'd used the gun.
yes,
against the
he
victim.
did. And for that, I would
But
argue.
it was after the marijuana had been taken.
It was after that, but my client also said that after Mr. Love had started shooting, that Mr. Mahias punched him, he pulls out his gun, and he fires. There's evidence to support the chamber from the victim's weapon having fired, and my client says as he's running away that he fires one return shot. The evidence supports that. The medical examiner mentioned that based on stippling of the bullet and kind of gunpowder, that it must have been between 6 inches to 2 feet away. But if we're gonna take Mr. Patterson's statement, I believe that until he is impeached, we have to take it in whole. And he does acknowledge that yes, he fired the shot, but it was after he heard the shot from the victim, Mr. Love, and the evidence support that Mr. Love fired his shots. I know we argue about what he could have done. You know, the argument is that, well, Mr. Patterson's weapon fired through a top left lung and through the unfortunate spinal cord of the victim, and that he would not have been paralyzed instantly, but the state would have us believe that he could then potentially be aiming a gun after suffering a shot like that. I believe it would support more that the victim shot first, potentially in response to being punched, and that Mr. Patterson returned fire. Going briefly to the self-defense argument, understanding that he did have a duty to retreat, I would concede that, but I believe when he spoke with the police, he does say that as I was running away, I looked back and shot once. Oh, excuse me, forgive me. He doesn't even say he looks back. He says he points the gun back once and fires as he is fleeing. And I would argue that that should qualify the requirement that he has a duty to retreat before he can take deadly force.
So if I have a duty to retreat, you're saying that as I'm turning to run away, I'm firing, that I can claim self-defense because I'm, quote, retreating while I'm shooting at someone?
Mr. Patterson says that he was firing shots as well. And so I believe if the other person is firing shots at you, that yes, during your flee, it would be reasonable for you to return fire. If, however, that person is not shooting, then it is not reasonable to be retreating and also using deadly force. But Mr. Patterson's statement is that as I was running away, I felt a bullet go by me, and I saw one go by Mr. Mejias, who was the other second person involved. And that as he was fleeing, he fired back.
Well, regardless of whether that's retreating or not, you basically, what you've got is you've got two conflicting stories of how this unfolded. And the law is pretty clear that the jury resolves those conflicts. So how are we supposed to get around that?
I believe that it was past credibility and not, and that's why I mentioned in other rare circumstances when the courts in Ohio and Indiana would allow for there to be some discretion given to appellate courts in reviewing the credibility of witnesses. But I do believe that Mr. Soto Morales' testimony must be thrown out in its entirety. I think that aside from just...
You want us to do that on a standard that's never been accepted in the state of Tennessee.
Well, I would argue that it's similar to the erroneous error. I would argue that it's somewhat similar to that. And so not that it's never been done, but the manifest weight is similar to the erroneous standard. Again,
Of course, it's kind of hard to argue that you're running away when the medical examiner says that the end of the barrel was 6 inches to 2 feet away from the victim.
Right, but in the heat of a moment, 2 feet, Your Honor,
It's still 2 feet. It's not going to get any better.
Well, okay, but it's away, and I believe it's different from.
I'm not trying to make light
Sure.
of your argument. All I'm saying is that it's hard to argue that you're running away when let's say a jury could reject that.
Okay.
If the medical examiner says that the end of the barrel was 6 inches to 2 feet away from the victim when the gun discharged. That's really what I was trying to say.
Then lastly, I would
I'm not trying to make light
No,
of
of course,
the
Judge.
situation.
The decedent's arm was outstretched, and I would make just a last argument that if it was outstretched and then 6 inches to 2 feet away from his outstretched arm, then it's not maybe as close as body to body. Lastly, I'd want to be heard on the Booker argument, Judge. Mr. Patterson is one of those rare cases where he is a juvenile convicted of homicide that bears a mandatory life sentence. I think the Booker holding is fascinating. I understand the Supreme Court wanted to stop short of telling the legislature how we should now be sentencing juveniles. However, I believe that if they have ruled that a mandatory life sentence for a juvenile is unconstitutional, that simply saying that, well, in 25 to 36 years, the Board of Parole could grant a hearing to then determine Mr. Patterson's or any client's availability, well, the paragraph simply states, to be clear, we are not holding that a juvenile may never receive a life sentence in Tennessee. I think that goes to the idea that there are some juveniles that could not receive one, right? They're trying to make it a point that we're not saying that you could never do it, but I think this here says, but consistent with the Supreme Court precedent, the sentencer must have discretion to impose a lesser punishment and to properly consider the offender's youth and other attendant circumstances. Well, I think the sentencer should be the trial judge. And for that reason, Judge Turner, I believe, should have paused and not immediately sentenced. And in fact, we waited to finish our sentencing hearing based on the Booker decision to see if it would affect Mr. Patterson's case. Thank you.
Thank you.
Good afternoon. May I please the court, Ben Ball on behalf of the state. If this court will indulge me, I'd like to start with a brief overview of the facts here. So we have first Mr. Soto Morales' testimony about what took place before the robbery and shooting. He essentially says that my little brother and his friend, which would be the defendant here, had showed up at the apartment talking about buying some drugs. He said that he'd like to get in on that. And then they said, well, maybe we're going to steal the drugs. And he initially said, yes, I'd like to get in on that too. And then he thought again of it and advised them not to do it. While this is going on, the victim, Mr. Love, is driving around with some of his closest high school friends, and they're enjoying their day. During this, Mr. Love also purchases an amount of drugs. And he begins a text exchange with Mr. Mahias, I believe it's pronounced, about selling a portion of these drugs to him. And these text exchanges lead this car, which has Mr. Love, has his friend, I believe Mr. Bunch, and then Ms. Hudges and Ms. Martinez, sort of changes the deal, sort of lures them in, essentially, with these text messages. At this point, they eventually arrive at the apartment complex. Mr. Soto Morales testifies that he had come downstairs out of concern, and he actually saw his brother and the defendant with Mr. Love pass by and head into what everyone refers to as the cut. The people who were in the car, Ms. Hudgens, Ms. Martinez, they describe how this was a drug deal that was supposed to happen, as they understood it, at the car. They had the drugs, other parties should have the money, they go on their way. And that's not how it happened. They were told to get out of the car and taken to the cut. The next sort of piece of evidence we have that gives us information about what happened is the defendant's own statement. And what the defendant stated is that there was a robbery, that his partner took the drugs. And his next statement was not simply that then I got fired at and shot while retreating. What he testified was he put his gun in Mr. Love's ribs. This is so the robbery can take place. This is the force that is part of the robbery. They're a team. It's also consistent with what the medical examiner said about the shooting, which was that the victim was shot between the third and the fourth rib from close range. That's where Mr. Love describes placing the gun. And he's only moved it if it's touching skin 6 inches to 2 feet before he shoots. So I will now address the defendant's issues. I'm going to take these a little bit out of order because I think there are two issues that this court can dispose of pretty easily. Because there are two issues where the defendant is asking this court, as an intermediate appellate court, to adopt new law. First, we have the defendant's request this court adopt Ohio and I believe Indiana's rule of incredible dubiosity. It's a fun rule to say, but it's not a rule that this court as an intermediate appellate court can adopt. The jury is tasked with determining credibility.
But he also argues that while we may not be able to adopt that rule, that there are similar variations within Tennessee law that we could follow. Can you respond to that argument?
The defendant's Mr. Soto Morales does not fall with any other Tennessee rule that would bar his testimony. The defendant is essentially arguing that on one hand he testified that he didn't participate in the robbery, and on the other hand he pled to it. People plead to things that, as Your Honor noted, that they don't believe they have done or in some cases did not do all the time. And it goes both ways. We see it where defendants who have done something much more serious will plead to something much less serious than they did. And what they plead to is not actually what they have done. But there was no inconsistent testimony amongst statements that he was making to the jury. I mean, the jury heard he pled as well. The jury gets to evaluate what they think of that plea in light of his testimony. I think it's pretty easy to resolve. He didn't want to testify against his brother, and this is how he made it happen. So this court can resolve that one pretty easily. Cannot adopt new law. And I would say the same is true for the Booker issue the defendant raises. Booker resolves that. Booker takes care of what we do with juveniles convicted who are given a life sentence. He will get a parole hearing at a different time than someone who was convicted, who was an adult when they committed the offense. That resolves it, and this court's not in a position to overrule Booker. Turning to the defendant's other sufficiency issues. Not only did the jury was not the sole arbiter of Mr. Soto Morales' testimony, his testimony, which was fairly limited, was indeed corroborated. He testified about essentially the planning stage, and then he passed by the other defendants and the victims. This is corroborated by the robbery itself, by the defendant's testimony, by the testimony of the other people in the car who described them, the two men being taken out. It is corroborated by the numerous text messages that show them luring them in. It's also corroborated by the 9mm shells found at the scene. And Mr. Soto Morales said that Patterson had a gun tucked into his waistband. Patterson admitted to firing that gun. So Soto Morales' testimony is quite sufficiently corroborated, and we are still under the law at the time that accomplished testimony had to be corroborated. And there is sufficient evidence here that there was a robbery. These drugs were taken by force. As I noted, there's a gun in Mr. Love's ribs right about the time these drugs are being taken from him, and the defendant's the one putting the gun there. This is a robbery, and there is sufficient evidence of it. And there's sufficient evidence, and I know if we covered this, the defendant argues there's no evidence that he knowingly pulled the trigger. There is abundant evidence of that. And there's abundant evidence for the jury to credit here that this was not self-defense. First and foremost, the jury was charged with the defendant had a duty to retreat. As your honors noted, this shot was fired from 2 to 6 inches away.
Can I be retreating if I'm 2 feet away, though?
You can be in the process of retreating, but you can't have retreated yet. And this, I think you have to take into consideration with the defendant's own statement about where he put the gun. He put it to his ribs. That's where between the 3rd and 4th rib from a short distance. It's not consistent with his claim that he was firing blindly behind him as he left. The bullet entered this victim's body where he had pointed the gun to sort of essentially restrain him during the robbery. So the jury was entitled to reject this self-defense argument, and the evidence supports the jury on that. I believe that I have covered all the defendant's
Can I
issues.
just ask a logistical question that popped into my brain that you may not, you may know the answer. How do we ensure Booker takes place?
That's a good question. I think the answer would be if a defendant doesn't get this parole hearing.
Because it's not statutory. I mean, it's a Supreme Court opinion. In that one case, I recognize they're saying it applies to everyone, but how do we ensure that Booker takes place for every juvenile?
I think the key would be that if a defendant reached 25 years without a parole hearing, I think the defendant would file habeas would be the answer to that.
Okay.
But I think otherwise what the Supreme Court is telling us in Booker is it's self-executing. They're saying, state, you forward this to TDOC, this is the way it happens now. And presumably that's the way it will happen with this defendant, but he was not entitled to a different kind of sentencing hearing under Booker. Booker resolves that with the parole hearing.
Thank you.
And if there are no further questions, I would urge this court to affirm the judgment of the trial court. Thank you, Your Honors.
May it please the court, if I could briefly kind of piggyback to the Booker argument. The purpose of the Booker opinion is to say that Tennessee is an outlier to all of the 49 states. We alone give mandatory life sentences to juveniles by 15 years more than the nearest other state. the purpose of Booker, I think, focuses on it is not illegal to give a juvenile a life sentence. It is illegal to give a juvenile life sentence without first factoring in, is their age something that should be considered? When Judge Turner immediately sentences him to life after the jury's verdict, well, it's impossible for Mr. Patterson's age or youth to be factored in. The Supreme Court, close to begs the legislature to finish the job. I think the Supreme Court got the attention of everyone and says, hey, we're doing something different than everyone, and it is unconstitutional as it violates the Eighth Amendment. And so we're going to adopt, I think very cleverly, a law that hadn't been repealed to serve in place. But at the very end of the opinion, it welcomes and asks the legislature to further this along.
But if the Supreme Court can suggest all they want to the legislature what they think the legislature should do, the legislature doesn't enact it statutorily. Your client's not entitled to something that the legislature didn't say and the Supreme Court didn't even say he's necessarily entitled. The Supreme Court is just saying, look, the only thing we can do is we can set a benchmark date that if you haven't had it, you can have a parole hearing by this date. But the Supreme Court can't say you get a different sentencing hearing because that's a statutory question, is it not?
Well, but I guess the language of, because we conclude the Tennessee's mandatory 51 to 60-year sentence violates the Eighth Amendment, I think that they're saying that as it was written and the fact that it is automatically applied, that's why they even, released the Booker opinion that something has to change. And I think that they're saying, as it's currently written, we are finding it to be unconstitutional. And you are correct, Your Honor, that if the legislature does not do anything, then I don't believe that changes the narrative of the opinion, which says that the way it's happening now is wrong. And the focus is not on what the Board of Parole should do in 25 to 36 years. Again, I think, because that was the 25 to life that I'm sure the court is aware of, that, for all defendants, they would have a time to come back and say, hey, look at how I've been a model reformed person. But the only reason the juvenile is getting it is not necessarily for the behavior they've shown as they've been incarcerated for 25 to 36 years, but because their youth should be considered. And the logic of considering a juvenile's youth 25 to 36 years after the offense to say, well, yeah, you know what, when you were 16 and this happened, I think your youth did affect it, doesn't go, I think, against the nature of why they believe we needed to change.
Statutorily, a defendant's convicted of murder.
Mm-hmm.
What sentences as a trial judge can I impose?
Please say that again.
Under the statute, under the criminal sentencing statute, a defendant is convicted of murder. What sentencing options do I have?
Right now, I don't believe anything other than the mandatory life sentence, but I believe
So
Yes.
to your argument that the trial judge should have somehow considered your client's age, okay, well, he can consider it all he wants, but his only option is life.
But then I think then that would render the Booker opinion with no teeth, in that it would have no
No,
purpose.
Booker has teeth. It has teeth in two ways.
Okay.
It has teeth in legislature. We think this is wrong. You need to fix it. And until you do, we are ordering that the Board of Parole has to have a hearing at sometime between 25 and 36 years. So it has teeth, but the Supreme Court can't impose a statutory requirement. They just have to tell the legislature, here are your two options. You can either fix it or you can go with what we've done.
I believe it would have been better if Judge Turner from the bench had ordered a hearing within 25
Well, that goes to the
36
question I
years
asked the state.
versus
How do we
having-
ensure it happens?
Right.
Does it need to be included on the judgment form?
And if I could finish that, then
Yeah, please.
thank you. Yes, I do. I believe that's a good response if he could file for habeas, but then we would be putting the onus on the defendant to figure out how to make sure their constitutionally guaranteed right was effectuated, whereas a better solution, and I think as evidenced by the delay in our sentencing, is that if Judge Turner would have been allowed to still have a life sentence, but said, in addition to this, I am ordering that between 25 and 36 years at the discretion of the parole board, that Mr. Patterson be reviewed, that would have been a better remedy than simply hoping that Mr. Patterson knows in 25 to 36 years that he needs to make sure that he effectuates his Booker amendment. So, thank you.
Thank you. All right, Madam Clerk, would you call the next case, please?
State of Tennessee versus Tevin Wayne Griffin.